Once again, welcome everyone. Thank you for joining us for today's webinar. I am Niveta from Relativity Management Solution India Private Limited. I would like to introduce today's presenter, Mr. Akash. He is a successful young business owner, speaker, innovator, and payroll expert who helps business leaders. He is the director at Relativity and he is well known as a financial specialist for over 13 years now. He is also a frequent guest at event hosted and NSDR, NIPM, TIDE chapter, IIHR related to human resource, finance, taxation, shared service. He has conducted more than 250 sessions offline and online as well as Relativity regular webinar every month. He is the host of Relativity Knowledge Series, a young YouTube channel to help HR professional and the lead author of Relativity's blog. It's time to start our webinar. Let's start and over to you, sir.
Hey, thank you very much for that quick introduction and a wonderful good afternoon to everybody on this webinar. It is a lovely dusky afternoon, at least the place where I am, and I think with the depression in the Bay of Bengal as well as the Arabian Sea, it is going to continue to be this way for the next 1 or 2 days at least. So a webinar in the afternoon, and that too something related to a topic which is kind of difficult. It is quite a difficult job, but then I can assure you that I'm going to do my best to keep you all absolutely engaged, and more importantly, to drive the very reason why we are conducting this webinar. So just to give you a quick recap, we had our monthly webinars. Relativity conducts every second Wednesday of every month. We conduct a webinar which talks about updates in payroll, compliance, accounting, or taxation, as in how the case may be. So just last week we conducted this webinar, and this was predominantly, I can say if not 100%, but at least 95%, we only spoke about this particular topic because this was such a large and an instrumental topic to speak subsequent to so many battles, right from 2014, and we are into 2022. This particular topic has roamed around multiple states and then finally at the Supreme Court's doors. The discussions for this topic at the Supreme Court started in 2021, and finally we have the verdict that was announced on the 4th of November. So more importantly, what I wanted to share is we had about as usual 100-digit participants during the last Wednesday's webinar, and we thought this is such an important topic. And I believe, it is necessary for a lot more people, a lot more audience to get to know about this topic. And hence we quickly organized this one again as a repetition. And this is completely live. It's not pre-recorded or anything. So I am a live person talking to all of you, and you are live people listening to all of to us. And thank you very much for the time that you've earmarked for this particular topic. So what we are going to talk about is predominantly we'll talk about what the Supreme Court verdict says, and we will also, over a discussion, chat or whatever, we will also go into details about how employers have to be prepared on the EPS amendments verdict by the Honorable Supreme Court. So with that bit of a intro, let me jump right into it. Before we get into the verdict itself, I think all of you should know what it is. Is it not? Why don't you guys take your thumbs and put it on the chat? Do you want me to elaborate on this slide? What is this whole hangama of the EPS amendment scheme? What is it? Do you want to know? Do you want me to spend about 5-10 minutes on this? I'm looking forward for your responses on the chat. If you already know, if predominantly people already know, I would like to skip and get right into the action. But then if there are people who would like to know, okay, I can see a lot of people saying yes. Okay, great. So let me take that 10 minutes and let me tell you what this is all about. In 2014, do you know, by the way, that the Employees Provident Fund and Miscellaneous Act, when it was introduced in the 1950s, originally had no pension scheme at all, right? There was no social security. It was a provident fund. It was a lump sum money that people would get when they retired. So this was how it started in the 1950s. But I believe, our society and the industry recognized that there is a need for social security after retirement. So not only that employees should get a lump sum, but they should get also some kind of an annuity, either monthly or quarterly or annually, whatever the case may be. That should also be there. So the EPFO, because they were handling the social security, introduced employees pension scheme in 1995. Right. So this employees pension scheme that was introduced in 1995 gave ability for the participants or for the members of the EPFO to automatically get enrolled towards this employees pension scheme and draw a certain monthly pension after they retire. So we all know, right, that the retirement age is 58. So after 58, automatically what would happen is they would get a part of their contributions as lump sum. They would get that back as the EPFO accumulations, and then a part of what they had contributed would be paid to them as pension scheme, right? So this happened in 1995. Initially, they started with a very small value. I think it was 5,000. Then they changed it to 6,500. And then subsequently, they increased it to 15,000, the value that we know today. And probably in the next few years, this 15,000 may also get increased, right? So what it essentially meant is up to that 5,000 or up to that 6,500 or up to that 15,000, you could participate in the employees pension scheme with two options. Either you can limit your contributions to that. I'm talking as employers. 12% of basic limited to the 6,500, limited to this 5,000, or limited to the current rate of 15,000. And we all know that the 12% that the employee contributes goes directly into the provident fund. And the 12% that the employer contributes, 8.33% goes towards the pension scheme, and the remaining 3.67% goes to the provident fund. The employer's contribution is then bifurcated, right? Now, this employees pension scheme amendment of 1995 amendment, which came out in 2014, what it said is that it capped the maximum pensionable salary at 15,000 rupees. So earlier to that period, what they said is, if your salary is 30,000, you will get pension in accordance to that 30,000. If your salary is 25,000, you would get pension in accordance to that 25,000. If your salary was 70,000, you would get pension in accordance to your pensionable salary. But in 2014, this was capped at 15,000. Now, you all know how this pension scheme works, right? They get our contributions, 8.33%. This forms the corpus, and the interest from this corpus is what is paid out of pension. So what these lawmakers or rule writers envision is that we may not be able to match the future salaries of India Inc., right? And then they decided to cap it. One. Second, they also thought that, okay, if we are not going to cap it, the interest that is going to come out of this EPS scheme corpus may not be sufficient for future, actuarial, it's called as an actuarial valuation and all of that. So one thing that happened in the amendment of 2014 is that they capped the maximum pensionable salary to 15,000. So this is one thing that has happened. The second thing that happened is whoever wanted to contribute beyond 15,000 were given an option, right, for a period of 6 months. They were given that option for a period of 6 months. The third thing that happened is what the EPS amendment said is that if you want a pension, if your salary is more than 15,000 rupees, then you might as well contribute the 1.16% that the central government is contributing on your behalf. So what they said is that because your salary is more than 15,000, you are considered as rich in quotes. And hence the central government will not contribute this 1.16%. You have to contribute it. So that is what you can see here. And then the third thing that happened was, as I told you, that this option to get pension on actual salary, every member of the EPS scheme as on 01/09/2014 was given 6 months time to exercise this option, right? So these are the four things that happened in the amendment of 2014, the large ones. Of course, there were a few smaller amendments also that happened, which said the pension, how to arrive at the pension, right? So the formula was changed. Earlier, the formula was 12, the last 12 months average salary was the formula. With this amendment, they made the last 60 months average salary as the formula, right? Which means that over the last 5 years, as on your date of retirement, over the last 5 years, what salary you had drawn, divide that by 60 is what will be your pensionable salary. This was the smaller amendments, but these are largely the larger ones, right? So with me, one, they capped the maximum pensionable salary at 15,000, which means from a specific date onwards, nobody can opt for pension on actual salary. They can only opt for pension up to 15,000 rupees, even if your contribution is at 12% of basic, right? So this was one thing that happened. The second thing is they gave option to opt for actual salary, pension on actual salary to all the existing members. We are talking about the new members. Now I'm talking about the existing members. So all of these people were given a timeline of 6 months to exercise that option. The third thing that happened during this amendment was the central government's 1.16% on the salary exceeding 15,000 will not be paid by the central government. The employees were asked to bear that cost, right? So these are the things that happened, and the whole journey from one verdict to another is basis these four items. Yes, if you have if I'm not clear, or if you would want me to explain it once again, please put it in the chat box. And also we have participants on YouTube, we have participants on LinkedIn, and God knows in whatever media, social media that you are. Even if you put there in your chat box, my team is going to relay it back to me. So don't hesitate at all. Please put it there on the chat box. I'm looking. Okay, PF salary is basic. So there was a question. PF salary is basic plus DA. So it is basic plus DA, not basic plus HRA plus DA, right? Yes. If you can repeat the timeline. Okay, I'm going to repeat the timeline once again. In 2014, there was an amendment to the Employees Pension Scheme 1995. The amendment said that we will now, moving forward from this point onwards, we will cap the maximum pensionable salary to 15,000, which essentially meant that if you drew 30,000, if you drew 40,000, if you drew 50,000, from that point forward, you will not be eligible to get pension on that value. Rather, you will be eligible to get pension only on up to 15,000 rupees. Yes. Second, for the existing members, all the existing EPS scheme members, they gave an option to opt for pension on their actual salary, right? And this option, this members had to exercise within 6 months if they wanted on actual salary or not. This option was provided. And third thing that happened during this amendment was what the EPS guys told is that the central government will not contribute 1.16% on the salary exceeding 15,000. So you have to contribute it from your pocket, right? So these are the three things that happened predominantly. There is also another thing that happened, which is the way pensionable salary is going to be computed, which we are not talking about here at all. I think it should be in the next slide. Okay, nevertheless. So what happened after this amendment is there was widespread chaos. Imagine you were a part of a social security scheme which promised you something, and then suddenly all of those who were going to be a part of employees provident fund after 1/01/09/2014, they don't have that social security scheme anymore. This was not taken rightly. So a lot of civil suits against the EPFO's amendments were filed in Delhi, Rajasthan, Kerala High Courts, saying that these amendments are unconstitutional. What they mentioned as unconstitutional is because of these three reasons. One, it said right to social security. You are only giving right of social security until a certain level. Beyond this level, which is 15,000, that is the right to social security. Beyond 15,000, if I earn something, I'm not going to get social security, which is not acceptable, is what the civil suits were against. Then the second issue was lack of transparency and clarity. At that point in time, nobody knew how to pay this 1.16%. Nobody knew what would happen if I don't opt. What is the default scheme that should be, that is automatically opted? And if I have to exercise, what is the methodology to exercise? None of these items had clarity. So there was lack of transparency. The third is issue of non-parity. Now, what the members said is, boss, you are collecting money from us and you are investing that in a corpus and you are giving me the returns of the money that you are collecting from us. So why are you asking us to pay 1.16% additional? Because I am earning more than 15,000, you cannot differentiate me with the one who is earning less than 15,000. So these were the three predominant issues in all of these courts and all of these judgments that were spoken about at length. A lot of deliberations were conducted, and after a couple of years, all the courts ruled against the EPF. Very it was landmark judgment, I can say, that the High Court of Delhi, the High Court of Rajasthan, and very importantly, very recently, I think in 2019, the Kerala High Court also came very heavily on the EPFO, saying all of these amendments are null and void. Now there were cases filed, there was so much of chaos. So what is it that went to the Supreme Court? EPFO then knocked the doors of the Supreme Court of India. Of course, right? When above the High Court, there is only the Supreme Court to which you can go. Now, what does the SC verdict say? Right? In a very, see, the original SC verdict is 52 pages. It has about, I think, 1,400 or 1,500 sentences, not words, sentences. So we are not going to get into that extraordinary detail. I'm just going to compare, okay, what was the case about and what was upheld. So the Supreme Court said that they are upholding the amendment of the Employees Pension Scheme 1995. The Supreme Court said that EPFO's laws allow it to cap the maximum pensionable salary as on 1/9/2014, right? Do you know what is the situation now? If any member, while being inducted in EPFO, is earning more than 15,000, they are not eligible for EPS at all. This is the current status. Now, this is as on 01/09/2014. So they have upheld that. The second thing that they also upheld is the option to opt for pension on actual salary was correct. That is also something that the SC said is correct. Now, what did they not agree is the other two items. What they said is, oh, I see somebody is using the mouse. Okay, how can I clear? Okay, done. Guys, please don't use the mouse. Thank you very much. So, I am reminded of my dog. Coming back, this 1.16% of additional salary exceeding the 15,000, the pensionable salary. What the Supreme Court said is, no, you cannot ask this to your members, because in the law, in the employees pension scheme, the law which allows EPFO to operate the pension scheme, the central government or the constitution has not given you this right to ask this 1.16% from the members. So this is rejected. You cannot ask it any forward, right? The second thing that they also said is, you have confused the members. Until the amendment, what you said is everybody gets social security, which is pension, on their actual salary. This is what you mentioned. Now, from this date onwards, what you're saying is you have to exercise an option to get it on actual salary. This shouldn't have been the methodology. The methodology should have been otherwise. The default option should have been what was carried on as a practice, right? All this while should have been the default option. And if somebody did not want pension on actual salary, you should have given them the 6 months to opt out of it. That is what you should have done. So you have committed an error. So this is rejected, is what the Supreme Court verdict has upheld. The other thing that the Supreme Court verdict has also upheld is, in between, there was another chaos which said exempted establishments, that is, establishments who have private PF trusts, their employees are not eligible for social security. So that was also squashed. This was also agreed by the Supreme Court, right? So we are clear on this. Please give me a yes if you all are clear. Otherwise, I'm absolutely fine to run it once again on the chat, because this is very, very important. Give me a yes if you're all clear. Okay, wonderful. So I see a few yeses. Please summarize. I will definitely do that, Nivya. I will definitely summarize. But until now, I want to know whether both of us are on the same page. I am talking about the Supreme Court verdict. It has upheld that the maximum, that EPS amendment in 2014 about the maximum pensionable salary is good to go. So that is right. It has also upheld that the option provided was okay. But what it has not upheld is you cannot ask for people the 1.16%. At the same time, you also cannot change your default option from a practiced default option. Suddenly, you cannot jumble the option, because EPFO, EPS is a social security scheme, and this is absurd, is what they said. Right? So we are all okay on this. Okay. Good. So with this, now what is it that Supreme Court has done to counteract the option, right? Whatever option was provided is not right. To counteract that, Supreme Court used its extraordinary powers. Supreme Court is like the god of the Constitution. So it has some special powers, like a genie, right? You rub the genie and the genie comes out. So Supreme Court rubbed its lamps, the extraordinary powers that the Constitution has given to the Supreme Court, and Supreme Court said, see, you committed an error to the EPFO. you shouldn't have done this, but we are 7 years after the 8 years now, after the verdict has, after the amendment has come. Yet there are significant percentage of employees who will benefit out of or who are disadvantaged because of your amendment. So we are using our extraordinary powers and we are opening up a window for people to go back in time and exercise this option. So let's say if I, on the 1st of September 2014, for some reason did not exercise my option to opt for pension on my actual salary. Now, Supreme Court has given me 4 more months, right? Supreme Court has given 4 more months from the 4th of October to opt for pension on actual salary to all those members who were to all those participants who were members of the employees pension scheme as on the 1st of September 2014. Do you know how big of an administrative task this is? Only if you can imagine the magnitude of this verdict, right? You should know that there are over 1.9 crore members of the EPS, with over 60% of them, qualifying to be before 01/09/2014. Please remember that this option is not available for those who were not members as on 01/09/2014, which means, let's say if the employee's joining date is 2nd of September 2014 or any day after 2nd of September 2014, they don't have this option. Their pensionable salary is actually capped at 15,000 only. This option has been enabled only for those who are members, who were members of the employees pension scheme as on 01/09/2014. So all of those employees have 4 months for them to now go back and make the declaration that I want pension on actual salary and not on salary capped at 15,000 rupees. Yes. Now I want to ask about 90 and odd participants in this webinar. How many of you are members of EPS scheme or EPFO as on 01/09/2014? If you are, tell I am. If you are a member as on 01/09/2014, tell I am. You can type I am. Okay, so we have a few. Wonderful. So a lot of them. Okay, guys, you are lucky, I can say, because this is the one time that Supreme Court has come to our rescue. So all of those who have said you are, all of those who have said I am, you know how important this verdict is for you, right? If you had not opted for salary, for pension on actual salary from the 4th of October until the next 4 months, we have that time. Even I am, just that I didn't have an option. But then, we all have this golden opportunity to opt for pension on actual salary. Otherwise, our options are only pension up to pensionable salary of 15,000, right? So this is a very, very, very important window that Supreme Court has opened on judgment basis, right? Now, there is another Pandora's box that has opened administratively. How will this be executed, right? So, how many of you want to know what are the permutations and combinations that may happen? I'm sure the EPFO officials are spending sleepless nights after this SC verdict has come out. But to foster a discussion, how many of you want to know what administrative initiatives need to be taken? If there are enough people who would want to know, I will go into it. Otherwise we can just move on to the employer's responsibility. Effective date from 4th October or 4th. Oh, sorry. Okay, Shrikant, thank you for pointing that out. It is actually 4th November. That's a typo. Thank you very much for pointing that out. Neha says she wants. Neela says she wants. Who else wants? Saurabh says yes. Arun, yes. Thanks for the correction. Yes. So not many people have said, but I'm going to quickly take you through that. Despite a few of them, only a few of them opting for it, because it's such an important judgment that we need to know as employers. I'm sure all of you are representing the company, or either in the payroll or the compliance or the HR department of your organization. So you should actually know. First and foremost, you are not expected to pay anything, right? So what has to be administratively done is, if you opt for that particular option now, the EPFO has to calculate, and has to, from 2014 onwards, it will have to calculate by itself and move funds from the employee's provident fund kitty to your employee's pension scheme kitty. This is one thing that the EPFO has to do. If this has to do, if this EPFO has to do, it also has to reverse all of the interest that has been paid to us on the employer's share, on that part that has to move from the EPF to the EPS. The third thing is, Supreme Court has clearly said that this 1.16% is unconstitutional. You shouldn't have got it. But the Supreme Court has also said that we understand, you cannot refund the money back to the members. So think about what you are going to do. Think about how you are going to, adjust this in the future contributions. And Supreme Court has also given 6 months time for this order, for this 1.16% not to be collected from the members, to be kept in abeyance. So 6 months time has been given, which means we will continue to contribute the way it is. If we were contributing 1.16% until now, we will continue to contribute it for the next 6 months until EPFO comes out with a permanent resolution. But this 1.16% should not be collected from us, is what the EPFO has now, is what the Supreme Court has mentioned. So what is going to happen with that 1.16% that you may have contributed from the 1st of September 2014 until today? So we don't know. That is something that the EPFO has to administratively clarify. Imagine if you have withdrawn your provident fund. Not closed. If you have partially withdrawn your provident fund, and the money that is available is not sufficient to cover your, actual salary contributions to the EPS, then what happens? We don't know. So that these are all operative parts of the administration, of the administrative task, that I'm sure EPFO will come out in a few days or probably in a few weeks. But I believe that the magnitude, again, I'm stressing on the magnitude because it is opening a plethora of questions of how this is going to be executed. Nevertheless, I am sure that for execution, we are not going to have 4 months. We will have much lesser time than 4 months. Right? So what should employers do? Right? First, we have to sensitize employees who have joined on or before 1/9/2014 regarding this change. Until now, there is not widespread, people know that something has happened, but nobody knows exactly what has happened. And a lot of questions we don't know the answers for. And I'm sure there is not going to be enough time for EPFO to come out with the administrative changes, and then for us to reach out to our employees and tell them what this is and blah, 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 and da, 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 all of that. So I think it is important for us as employers to take a list of those employees who were members of EPS scheme as on 01/09/2014. So you'll get one list, right? Of that list, you will have people who are currently continuing to work in your company. And then you will have people who have quit and who have left. So you don't have to worry about who have quit and left. I think their new employer will worry about that. Right? But then this list of employees who are currently still working with your organization, we have to sensitize those employees about this change and what potentially can happen. All of those items have to be sensitized. So maybe if you are a large enough organization, you can write a note. You may have some kind of a compliance tool, like how we provide to our clients. You may have a compliance tool on which you can post a write-up on this, or probably a PPT, or maybe you can organize an internal webinar for your own employees who qualify under this bracket, and then sensitize them of what may be coming in the next few weeks. Second, and the most important thing that we should also do is, once the option is enabled by the EPF, we have to rush to make this joint declaration. It is still going to continue to be a joint declaration, which means the employee says that I want, a pension on my actual salary and not on 15,000, and the employer endorses this particular request of the employee. So it is going to be a joint declaration. The reason behind this joint declaration is because the EPFO wants to make sure that the employee and the employer both are aware of their respective roles in this, because that the 12% of employer's contribution is being diverted to EPS. It is not the employee's contribution which is diverted to EPS. One. Second, if you are going to divert 8.33% of your actual salary to EPS, then it is quite a substantial money that is going to go into EPS, right? And you don't want to go wrong, because once you exercise that option, there is no going back, right? So I think with all of this, these are the two most important things that we see, and that we are recommending all our clients for whom we handle compliance, for whom we handle provident fund compliance, as well as labor law legals, that they undertake this distribution of information without any further delay, because you don't want employees to read about it somewhere and then start sending emails, raising help desk tickets, saying, okay, this judgment has come, what are you going to do, blah, blah, blah. It's only going to create a lot more noise. And maybe our help desk employees are not aware of this. Maybe we ourselves may not be completely aware of what the things are going to happen for. Okay, I think we are at 3:10, 20 more minutes. I would want about 15 to 20 minutes for questions. So guys, if any of you have questions, or if any of you have more information than what I have told, please put up you can raise your hand, right, in Zoom. Do you know that you guys can raise your hand? So please put up your hand so that my colleague, Divya or Niveta, whoever it is, will be able to unmute you and you can ask your questions. Alternatively, you can also post your questions on chat and we will take the questions one by one. Of course, my team is super efficient. I see that they have already started answering questions.
Hello.
Arun and Padmajyoti and everyone, please hold on.
Hello.
Please hold
Hello.
on until I finish. Please hold on until I finish. Arun and Padmajyoti and everyone, if you can hang on to answering questions, we'll take them one by one. One of the things that you want to specifically take care are the employees who are retiring shortly, right? Because for them who are going to retire, let's say in the next 1 year or 6 months or 2 years, for them this would mean a big change. right? This would mean a big change. So you may want to give specific attention to these employees who are retiring shortly, who were members of the EPS scheme. Now, when I say who were the members of the EPS scheme, I also want to highlight the fact that they need not be only at your company. They could have come to your company after 0109-2014, but they were, members of the EPS scheme even before coming to your company, right? So even those people, we have to do the joint declaration. Is what I guess, because it's always where the employee is currently working, which will decide the liability and the responsibility of the employee. Second, those employees who were contributing to 12% of their actual salary up to 0109-2014, and for some reason they failed to make or to opt for the pension on actual salary, so automatically they got bumped down to pension on the maximum pensionable salary at 15,000. So all those employees, if you have data, if you have access to those records, that is also something that you should definitely look at, of course. And then there is this large population, which is the item number 3, who were actually a part of EPS as on 0109-2014. Right. So this is also something that you do before we open up for chat as well as for few questions. A quick summary of some facts about relativity. You would want to know who's giving this seminar, who's doing this webinar and all. So to a lot of people whom I already know, who are a part of this webinar, a big hi to every one of you. If you already know me and we've met, we've spoken, please say hi on the chat. It's so nice to recognize people whom we've always known. So hello to all of you. But for those group who just joined this webinar and who don't know about relativity, we are 13 years and young. We have 153 clients in counting. We process about 1.2 million transactions a quarter. Our accuracy rates are 99.5. We operate at 16 wonderful cities of India. And about 500,000 Form 16s are issued under our advice and our processes. And one thing that my team has added in today's webinar, I mean, in the webinars moving forward, is the client retention rate, because apparently one of our management consultants said that you should be proud of your client retention. So we decided to add that. We have about 99% client retention. Thank you for all those clients who are there on today's webinar. Thank you very, very much for working with us and making sure that we are your partners and we will continue to add value. We do so much, but what is the exact thing that we do? We are into payroll, we are into taxation, we are into compliance, and we are into accounting. We work with we work with employers who have 100 employees, 2 employers who have 33,000 employees in India, and we add value in all of these verticals that you can see on your screen. Make sure that you connect with us on LinkedIn. Please also connect with us on YouTube. It's a young YouTube channel. We're just trying to add some nice chota videos, and then it would be specifically useful for the HR professionals out there. And do subscribe to our blog.relativity.co.in. I'm sure my team is posting the links right away as you speak. Please also connect with me on my LinkedIn profile if you're not already connected. I'm active on LinkedIn, so anything that you want to ask, any questions, absolutely happy to take it up. Now we are going to the questions and answers. Divya, would you please kindly unmute the first person who put up their hand, and then we'll start taking questions. Ashish Banka, I think two hands I can see up. Ashish Banka, you could. Yes, Ashish, go ahead.
Do you have a question? Namaste. Thank you for such a wonderful session. My question is just for everybody, us on to be same page. What our understanding was that when we have this EPS contribution, I was a member and I was contributing at 15,000 at that point of time. What we were told that you have to have 10 years of continuous service to become eligible for pension scheme. And you can withdraw PF at at a lesser rate when you are 50, or at the superannuation when you become 58 years. So the entire amount which you contribute to EPS plus the interest which adds on year, the government does some calculation which we are not aware about what is their calculation methodology, and it is paid to us in monthly once you get superannuated from PF.
Correct.
There's another theory which is floating that the amount which gets accumulated in the EPS, now with this, since this will be a huge amount and we were following unlimited PF in our organization where the PF was not restricted to 15K. So the amount of EPS and EPF will become broadly the same equilibrium at that. So now will be when we become superannuated. So my two questions putting this context is, if we superannuate, the EPS will give us the lump sum amount, and from the interest they will give us the interest, or it will be calculating everything and then start giving us interest to us or our dependents until we survive. In your opinion, is it the right approach? I am 35 and we are looking at 23 years now since I will be a member. So do you feel this is the right kind of advice in the life, in the VUCA world which we are sustaining?
So Ashish, thanks for the context. One thing that does not change is the fact that you still have to, be a member of EPS for 10 years for you to withdraw or for you to get some kind of pension when you superannuate. So that law still continues. The second thing is, given the context that your employer did not limit PF contributions to 15,000, and they have been contributing at 12% of the actual salary, definitely this particular option will help, predominantly because we have, as you've rightly mentioned, we are in a VUCA world, right? And the pension from the government with the government securities guarantees some form of minimality. Today, if you look at, it's out of my own interest that I'm talking. If you look at fixed deposits, they hardly give you 5.5. If you look at senior citizen savings schemes, they give you between 6 to 7. PPF gives you 7.1. But the EPS scheme promises us something, and that is, as on the last drawn actual salary for the past 60 months, your pensionable pension will be calculated, which I believe is a fair game. Considering the volatility of interest, considering the risks to capital and all of that.
Thank you, Akash, so much for answering this. So what I understand that you are giving a thumbs up to this change and the declaration which we should go ahead with for our employees and ourselves.
Yes, in my personal opinion, I would opt for it because I definitely want a higher pension for me to be received when I retire.
Hello. The second question was, the pension is not refunded by the government. The entire accumulation and the interest is divided into the pension till we survive and to our dependents, right?
So that is not how it is. Our contribution is not divided and received by us. Our contribution goes into the corpus of the EPS, and the interest of that corpus is how the government is paying out pension to millions of its subscribers. Whether that corpus is earning the kind of pension that the government promises us or not is not our problem. That is the EPS or the EPFO's problem. We will still get pension as per our last drawn average salary for 60 months.
No, my question is, if we superannuate, will we get the EPF and EPS, both what we have accumulated and employers have accumulated? Everything?
No, we will only get the EPF. The EPS will get converted as pension.
Okay, understood. So we are not going to get a single penny from the accumulation of employee and the employer in EPS, right?
No.
Okay, thank you. Thank you so much.
Ghanshyam Das, you've also raised your hand. If you have a question,
Yes,
you can.
I have got a question. I have retired before 2012. I have retired in 2012. I was getting pension on 15,000 maximum, and there was no option letter to exempted organizations. This letter was given to unexempted organizations, and they are getting higher pension. So option is still not given by us who retired before 14. What
Sir,
is
I
the fate
understand,
of
but Ghanshyam ji, there is very little that I can do about it. This particular, Supreme Court verdict is as on 01/09/2014. Anybody who has retired prior to this verdict, unfortunately, has nothing to do, and and there is very little that I can solve at this point in time, Ghanshyam ji. Best wishes to you, and
we can file the review petition for giving the option, I think.
sir, you can definitely, please, there are legal options possible. Please, take it at your leisure. Thank you very much. I'll
Okay.
move to the next. There is one more person who has put up their hands. Prince Kumar Uttam Tools. Would you please ask your question?
Hello, sir.
Hello, sir. Good afternoon.
Yeah,
Yes,
good afternoon. Sir,
you are
my
already a
question is
prince.
that, yes, thank you, thank you. My question is that if anyone joined before that, this is the 2014, and currently he is working and not connected with all UN, because before was that manually, not was the UN.
Yeah.
So what will affect now?
I don't think that is possible, right? Because now it is so one thing, they have joined before 2014, right? Before 01/09/2014,
Yes.
which means they are still member of the EPS scheme as on 01/09/2014. So they can
Yes, yes.
still take advantage of this window, right?
Okay.
But what I don't think is possible is for them not to have UAN, because without UAN, I don't think a contribution can be made at all. Am I right? I think so.
Yes, there was the EPF and EPS both, but not connected before and this currently.
So I think they can still take advantage given the fact that they are members as on 01/09/2014.
Okay.
Right?
And if after that, if some days, if we will connected with both, it will be impact or not?
Sorry, please come again. Please ask your
I'm saying
question.
that कि अगर वो बंदा जो पहले काम कर चुका है, अगर वो ट्रांसफर करता है, उसको लिंक कराता है, तो क्या वो एप्लीकेबल होगा कि नहीं होगा?
तो डेफिनेटली लिंक करना पड़ेगा, एंड देयर शुड नॉट बी एनी ब्रेकेज ऑफ सर्विस.
Yes. No
अगर
break.
ब्रेकेज ऑफ सर्विस नहीं है तो लिंक कर सकते हैं, और दे कैन टेक एडवांटेज ऑफ दिस विंडो.
Okay, sir. Thank you, sir. Thank you.
Thank you. Now I think everyone have asked who and all has put their hands up. I'm moving to the chat. I think my team also would have started answering. I don't think there are any questions on chat. Are there questions on chat? Yes. So guys, before we start looking at the questions on the chat, I'm opening. Divya, would you please open the poll? I would love your feedback, all of you, and just take a couple of seconds for your feedback as well as some questions. If that helps us build better webinars like this for you as well as the industry around us. Yes, I am looking at some questions. I'm trying to see. Okay. So Bharani Dharan TV asks, I don't know if this was already answered, but let me anyway take it. If I am member as on 01/09/2014, but monthly basic salary is less than 15,000 at that time, am I eligible for this? 01/09/2014, but my monthly basic salary is less than 15,000. Am I eligible for this? I think So, Bharanidharan, I don't think the factor is about your basic salary, whether it is below 15,000 or above 15,000. There have to be two litmus tests. Test number one is that your employer should not be restricting, your the contribution to basic plus, to the cap, which is, let's say, at that point in time it was 15,000. So if the answer to this is yes, the second thing is you can opt for actual salary from that time onwards itself, right? So that's the answer to you, Bharanidharan. How will the declaration process happen, Ashish? We are not aware of that, but I think it is fair to say that this will definitely be driven through the employee's login as well as the employer's login. That is how it is. And just another reminder to all of you on the call that there is a lot of background effort that goes into designing these webinars, and we bring it to you. So please take 30 seconds of your time and fill up the feedback as well as the sales poll. It will be very useful for us. Thank you in advance. Fair to say that with all the digitization that has happened in the EPFO side, it should be fair to expect some kind of a request an employee can raise from their login, from their EPFO login, which comes to the employer for approval, and then the employer approves, is my assumption, right? But then we'll have to wait for the EPFO to come out with detailed administrative guidelines or clarifications of how it will actually happen. Okay, beneficial if the fund is in EPS. Okay, please, well, I think I've already done that. Saurabh asks, if one person already withdraws one pension, how will apply for second pension? Does PF combine both the pension in one, or how will they process? One of our employees was working for government organization earlier. After that, he joined our organization and completed his retirement age. I don't think if they have already withdrawn their pension, that is possible. Point number one. Point number two, employees pension scheme. So you have to be member of the employees pension scheme, right? The central government has a different pension scheme. It is not the employees pension scheme. It has a different pension scheme. So if you are a member of that pension scheme, that has nothing to do with this pension scheme. The 0109-2014 is only for those who are a part of the EPS 1995 scheme, correct? Which predominantly is only for private establishments or quasi-government establishments. Central government and state government have their own provident fund and pension schemes. What about employees joining after 0109-2014? Shweta, do you belong to that group which has joined after 0109-2014? I think what is the stand today is that if any new person who is joining employment for the first time is getting a salary of more than 15,000, then they cannot become a member of the EPS at all. So that's the stand now, which is what it is. Some people think that we don't need a social security contribution, so that is what it is. Yes. Retirement age means, is it 58 or as per EPFO or as per company's retirement policy? Retirement age is the superannuation age announced under the employees pension scheme 1995, which is 58. Okay, unmute me please. Right, employees who are retired after 0109-2014, how can they claim? So Rajesh, I don't think employees who have retired after 0109-2014 can claim, because the money would have already you would have already withdrawn your EPF accumulations. There is no way of how you can transfer money to EPS, so on and so forth. Should be a member on or before 01/09/2014 and not as an employee. Yes, they should be a member as on 01/09/2014. Is the pension fund mandatory? Currently, it is not mandatory. In fact, it is mandatory that you won't contribute if your salary exceeds 15,000. But until that amendment came, yes, it was mandatory. It was not optional. Yes, if anyone joined before, I think that was asked. Wonderful. So there are a few more. Okay, thank you, guys. What do you think? Time well spent. I'm sure you've also mentioned that in the sales and feedback poll, but then generally asking. I hope time is well spent for all of you. And I've already exceeded 3 minutes of my time. So, guys, wonderful. It was such a pleasure to be amongst you industry participants, the people who run the show at organizations. Thank you very much for joining. And we will keep in touch. Please don't forget to join us on LinkedIn. We have a nice quiz going on. I think there is one quiz every week, and it's been happening for 50 or 60 weeks now. So please do join us on LinkedIn for the quiz, and you can't win prizes because it's not a quiz for prizes, but you can feel good about yourself if you've got the right answer. Yes, with that, thank you very much. Have a wonderful, wonderful time and have a wonderful week ahead. Thank you. Bye-bye. Thank you. Yes, Bhavani, thank you. Thank you. Yes. Thank you. Wonderful and knowledgeable session. Thank you, Saurabh. Thank you. Thank you.